Is there a constitutionally protected right to flash your lights at oncoming traffic in order to warn them of an approaching speed trap? There's remarkably few legal rulings out there on this issue, and a quick search reveals very little guidance from either the judiciary or the legal community. That doesn't mean that this isn't a common occurrence. I hear about it from time to time, and there's a few instances out there of it being captured on video. Perhaps my favorite is an old video from the guy they call the Godfather of First Amendment auditors, Jeff Gray. I'll show you some of the footage of his encounter, then we'll go over the current status of the law on this question. This occurred in Florida near Jacksonville on I-10 and involves a classic Florida speed trap full of unnecessary government employees who have nothing else better to do than to harass people and to flex their egos and authority. Jeff sets the trap with the bait, and the cops can't resist it.
Just about to approach the Duval County lines out here, and they got quite a speed trap set up out here. They got the Highway Patrol and JSO out here, and I saw a DOT officer also. So what I'm going to do is I'm just going to flash my high beams, let people know to slow down, help them slow people down a little bit. We'll see what happens. Here's the speed trap right out here. I'll show you what's going on. There they are. A gaggle of them. Alright, I got one. He's pulling me over. He's back there. Got one pulling me over. See what's happening. Hey, how's it going?
Good, how you doing?
Good.
You alright?
Yes, sir.
What's going on?
I just let people know, help to slow people down.
That's it?
Yeah, that's all.
Oh, I thought you were calling for help or something. I'm like,
No. I'm good.
Okay. Let's see your ID real quick.
Alright. I'm audio and video recording, okay? I just want you to know. I just saw you guys out there. Actually, I saw the state troopers.
Mr. Gray?
Yes, sir.
Is this a good address?
Yes, it is.
Alright. Alright. Give me 1 second, alright?
Alright. Alright, I got two of them back there. They pulled me over. They say it's because they're wondering if I'm okay.
What we have here is an acknowledgement that Jeff was subjected to a traffic stop as a sole result of flashing his lights. There's no allegation of speeding, seatbelt, or other pretext for the stop. Remember, every traffic stop is already an investigative detention by definition, and therefore reasonable suspicion must be present to justify this invasion of Fourth Amendment protections. Now, reasonable suspicion is generally pretty easy to justify, even for the dumbest of police officers, in the context of a traffic stop. Basically, they're encouraged to lie. All they have to say is that they saw you violate one of the hundreds, if not thousands, of traffic laws out there. So here, had they known ahead of time who they were dealing with, they probably would have made something up, or at least they could have. But the first thing that popped out was this feigned concern about helping or protecting Jeff. They know that that's a lie. Jeff knows that that's a lie. They know that Jeff knows that that's a lie, leading to the next issue that pops up. So if this were true, there would be no Fourth Amendment justification to continue to detain Jeff. However, the footage clearly shows that they indeed do continue to detain Jeff. What likely happens is that the officers now go back to their police cruisers and discusses the situation, now being aware that Jeff is filming them. For police officers who were already willing to lie about the reason that they pulled Jeff over, this could be a problem. And as you'll see, their strategy is to stop Jeff from recording. But Jeff refuses, calling their bluff.
Hey, Mr. Gray.
Yes, sir.
Can you put that down for me, please?
What's the phone?
Yes, put it down.
I'd rather not. I like to have it recorded.
Mr. Gray.
Yes, sir.
Can you please put it down?
I'm not touching it. I got it right there.
Yes, I know. And I know what that phone does. Please put it down so it's not recording me, please.
No, sir. I'd rather not. I'm going to go ahead and record. I know it's my right to be able to record.
Excuse me?
I know it's my right to be able to record.
No, not to record me.
Yes, sir. Audio and video.
No.
I'll let you know when I first pulled up.
No.
It's a citizen have the right to film public officials.
Okay.
It's First Amendment protected free speech.
Okay. Put the phone down, please.
I just got it sitting there. It's recording. And you know it's recording.
Okay.
Am I being detained or am I free to go?
You're free to go.
All right. I just want to, I'm just recording. It's just for my protection of yours. So.
You want to go? Go ahead.
Can I get my ID
But-
back? Or?
I'll let you know. I'll let you know what I was gonna say as soon as you put it down. So you tell me.
Well, I'm not going to turn it off. I can't go anywhere without my ID. So. It's Officer Valero. I'm just trying to help y'all slow
Hey,
people
I'm
down.
gonna go. As a matter of fact, I just remembered about something else. I'm gonna check one more thing. So whenever you want to leave, just let me know.
All right. So I guess he's making me sit here until I turn the camera off, which I'm not going to do.
All right, Mr. Gray, everything's in order.
Okay.
You flash your lights that many times, we're gonna think you're calling for help.
Okay. Understood. Thank you.
Drive safely. Make
Thank
sure
you.
you use your turn signal.
All right. Be careful out there.
Even now, in 2022, there's still no clear federal law on the issue of whether there's this federally protected First Amendment right to warn oncoming traffic about a speed trap. But there's a wealth of clearly established law on the right not to be detained by the police in the absence of reasonable suspicion. If the officers in Jeff's video had just been honest about the reason that they were pulling Jeff over, and if they were able to point to a Florida statute that he was violating, they may have been justified in their actions, or at the very least entitled to qualified immunity. But, however, they basically admitted that they pulled him over in retaliation for warning other motorists without bothering even to lie about some pretextual reason for their doing so. Thereafter, repeatedly trying to intimidate Jeff into turning off his camera. There are no Supreme Court cases on this. There are no federal appellate cases, to my knowledge. There are only a couple of U.S. District Court opinions, that's the trial level, and a couple of State Circuit Court opinions. There was a 2019 memorandum opinion from the U.S. District Court for the Western District of Wisconsin, holding that a policy and practice of stopping, detaining, and citing drivers who flash their headlights to warn oncoming drivers of a speed trap violates his right to free speech under the First Amendment. That was Obrecht versus Splinter. So the First Amendment provides that Congress shall make no law abridging the freedom of speech. It protects symbols, nonverbal communications that express or convey a particularized message reasonably understood by viewers. That's Texas versus Johnson, U.S. Supreme Court. So flashing headlights could easily be placed into the category of expressive conduct under that definition. In the Obrecht versus Splinter case from 2019, that point was conceded by the state. However, even expressive conduct can be regulated by the government depending on the circumstances. For example, speech that incites or produces imminent lawless action, or is integral to criminal conduct such as fighting words, threats, solicitations. Another similar case from the U.S. District Court for the Eastern District of Missouri held in 2014 that this conduct was entitled to protection under the First Amendment. At least 2 state circuit courts have found that drivers have a constitutional right to flash their headlights. That was State versus Oregon in 2014 and State versus Walker from Tennessee in 2003. The problem with the lack of legal precedent on this issue leads to a big problem for potential plaintiffs filing civil rights violations lawsuits, qualified immunity. The standard for qualified immunity requires establishing that the police officer violated clearly established law. Where there's almost no established case law on a particular issue, that's going to be a tough task. However, as we saw from Jeff's video, if police are going to pull people over for flashing their lights at other motorists, they need to be honest about why they're doing what they're doing and identify a state or local statute that they're alleging this conduct is violating. Then the victim of that stop can mount a First Amendment challenge, and that's how this issue will become clearly established in the future. At the same time, if they're not being honest, only video footage is going to protect the motorist from pretextual lies from police officers, which, if documented, can establish liability for a Fourth Amendment violation with no good argument for the application of qualified immunity. As always, thanks for watching, and you'll find more information in the link below to my blog at thecivilrightslawyer.com. If you have a video you want me to see, please send it my way. Don't forget to subscribe and hit the bell notification so you don't miss updates or future videos. Please like, share, comment about this video. It helps the channel, and it helps our mission of exposure, education, and accountability. If you want to support the channel, please consider clicking the join button and becoming a channel member or sponsor. Remember, freedom is scary. Deal with it. See you next time.